on the clock when they were getting their gear on before they started work. And maybe you only clocked them in once they were starting their actual work. And they say, we should have been paid for that 8 minutes going back 3 years. That might only be, say, $1,000. But plaintiff's attorneys aren't, well, if you did it wrong with one employee, you must have done it wrong with everybody. So they file for class action status. Okay, now they say every one of your 100 workers over this period should have been paid that extra $1,000. Well, there's $100,000, and that's, if my math is correct. I think that was pretty easy. But in Washington, you get triple damages for back benefits due. So now it's $300,000. And in Washington State, the plaintiff's attorneys get attorney's fees. So they'll say, this took us 100 hours, and we're the smartest attorneys on the planet. We are worth $500 an hour, so we want $500,000 for the $300,000 we got for the workers. So it's just easy money to go after any employers who didn't do it right by the book. So many of these cases are very, very expensive. So being proactive, looking at your policies, training up your people, coming to this event today to try to stay in front of things is just smart. And if you ever do use an attorney, hopefully it's a little bit to just check in, make sure your plan is correct, or just not need us at all, can save you a lot of money. So what we're covering today.
Yep, I figured that might have gone to sleep on us. So.
We gonna make that work? Okay.
Well, I'll at least give you the next slide.
Okay, well, well, so about those mariners.
There we go.
Okay. So I'm going to start out with a few court decisions. I'm not covering everything new in employment law. We'd be here for a week, and probably even then not still hit it. I'm trying to get some of the highlights that have come out. There's going to be 3 court decisions that I'll cover, and then I'll cover some new laws that have been passed. The Burlington Northern case with Casey Taylor is huge. The takeaway, obesity is now a disability in Washington. Doesn't matter if it's related to a medical condition or not. If someone is obese, that is considered a disability, and everything else that comes in with disability, you can't discriminate based on it. You have to engage in reasonable accommodation discussions to see if the person, despite their obesity, can still do the essential elements of their job with or without accommodation. This is a huge change. And of course, bad facts make bad law. I think what happened is this particular employer, whoever had the person come into the office, probably was rude. Okay, if you set into my other harassment discrimination training, if you treat people respectfully and tell them the truth, you will eliminate many, many, many of your employment discrimination claims or harassment claims. Because people sue not because a law has been broken. They sue when they've been lied to, feel disrespected, or had their feelings hurt. So if you can just be truthful and don't be a jerk as a top-level approach on employment, it's going to take you far. But what happened is this person came in for an interview, and probably in somewhat of a disrespectful manner, they said, hey, you're obese. You can't do this job physically. You have to go pay for if you go out and pay on your own and get a medical doctor to say you can do this, then come back and talk to me. So he sued, and the court, because this is a sympathetic case, said this is always going to be an impairment because obesity is recognized as a physiological disorder or condition that affects multiple systems. This is going to be difficult because obesity is based on BMI, body mass index, and there are plenty of people who are in the obese category who are incredibly fit. You know, I have a friend who's a safety director over in Eastern Washington, a huge mechanical contractor, and he's probably 265, 6'1", and he just did an Olympic triathlon, right? He's incredibly fit. He's larger than he would like to be. But to say you're disabled is going to be offensive. You've seen those CrossFit women, right? They're 5'8", they're 168 pounds, which puts them in the obese category, and they got about 3% body fat because they're all muscle. So it's a delicate issue. I think it comes up a lot in construction. And this is an issue I've been wrestling with for years. It's nuanced, but there's safety, right? You are required to make sure every person on the work site can do that job safely without injury to themselves or others. And to me, there is a certain point where body weight is so great that it may pose a safety hazard to themselves or others. Like as a plumber pipe fitter, you're down and up on your knees all day long. Can you actually do the essential elements of that job without risking blowing out your knees or hips if you're 430? What about safety gear, fall protection, ladders? Most ladders are not rated over 350, 400 pounds. You get a 400-pound person and they got their tools and their belt. Now you got to worry about the ladder. Can they not use it? Are you going to have to accommodate by getting a special weight ladder? What about the ability to save and rescue other people, right? Often in a rescue situation, you count on your peer group to know how to rescue people. So it's complicated, top-level story. It's now considered a disability if someone is obese. Just don't shoot from the hip. Don't have people shoot from the hip. Have them check with HR before they have any yes, no, you can, you can't. Let's get you checked out. Can you safely do it? Please check with your HR department. If it's really dicey, they'll check with an employment lawyer to have a plan going forward. So that's a huge change. Any questions about this change in Washington? And all the unions know about this. I went to train at a union in Tri-Cities, and every single one is, yeah, we know about it. And like every huge person's like, yeah, we know it. We're protected now.
And so, Karen, of course, the court did not define obesity.
Not exactly.
Yeah.
So this is what it is different court cases are going to fine tune this. You don't want to be the employer that is fine tuning this law.
That's right.
So you want to stay as far on the safe side of it as possible, how you handle it. Again, being very respectful and honest and having a thought out plan will hopefully keep you in the category of employers that are not testing the boundaries of this law. Okay, there's a U.S. Supreme Court decision. A lot of these arbitration clauses, you agree that you won't sue in court. You will go through this arbitration for employment ones. You want to make sure that if you use those, that the person explicitly addresses class actions as well. And I agree that I will not participate or have class actions. So their own rights of action and class actions need to be included in the agreements. Again, in discrimination lawsuits, there can be certain protocol that a person has to go through before they go to court and claim them. Maybe it's union arbitration process. Maybe you're supposed to make a complaint to the EEOC or some agency ahead of time, and then you can go to court. In this case, the employer waited too long to bring up that issue. The person had added in some new claims, and the employer didn't make a fuss about it up front, and the court's like, if you've got a defense, you got to raise it early, or we're going to consider that you've waived it. Just being careful of everything that's going along. Has the plaintiff checked all the boxes and gone through the right steps ahead of time? And if they haven't, don't say we're not going to. They're not going to let you say, "Ah, ha ha, got you later." You got to raise it up front. Yeah, the courts don't like those kind of gotcha maneuvers. And crafty attorneys love them. We'll come on the back end. But I think courts in general, especially in Washington, they want everyone to have their day in court and for justice to be done, however you define that. And they don't really like people winning on technicalities. So if you do have a technical argument, raise it early. Now we're going to talk about the Washington State Legislature. And they're cranking out laws like never before that benefit workers. Anyone have a guess why this is happening?
The Democrats took control.
What was your name?
Shelby.
Shelby gets a gold star and an A for class participation. Because yes, we used to have checks and balances. I'm a assistant scoutmaster in my son's scout troop, and I do citizenship in the nation, merit badge counseling. and we talk about checks and balances. And we used to have that in Washington. Typically, we'd have a Democrat governor, but that wasn't always the case. But the Senate often was Republican, and the House often was Democrat. And so there was a little bit of check that things need to be reasonable to get passed and get in front of the governor. Well, now the Senate is Democrat, the House is Democrat, and our governor is Democrat. So we've lost checks and balances. So they are cranking out laws that are very protective of workers. They're backed by the unions. They know who butters their bread. And so it's not getting any more friendly climate for employers in the state. But what you need to do is be more educated, have better tools than your competitors, and you'll make a profit and stay in business. Because you're competing against other employers in the same boat, by and large. So these are some of the laws we're going to be talking about. I'm very curious how the Equal Pay Opportunity Act is going to flesh out as the lawsuits start coming. It first came out in 2018, and then they added some extra steps and provisions this year. And the purpose is we want to make sure men and women are equally compensated. So who does it apply to? It applies to private employers, public employers, all employers are subject to this. And here's the basics that came out for 2018. It uses gender, not just sex anymore, so the whole LGBT, everything. And it's wages, benefits, everything that equals compensation. And it is more expansive even than California's law, but it's still a little unclear what it means. But you're not allowed to deprive employees of career advancement opportunities or how they're compensated. And this is not comparing apples to apples. This is not saying, hey, if you've got a 5-year electrician male and a woman who's been there 5 years, let's make sure they're paid the same. Because that's been around forever, and that's a lot easier to prove. This is going across different job classifications. What does similarly situated mean? Your skill, your effort, your responsibility, similar working conditions. We don't care about the job titles. And I think there's going to be massive lawsuits, and they're going to come up with the dirt they need. This is an example. You've got the cleaning staff at a hotel, right? They come and clean the rooms. They're bending, they're lifting, they're scrubbing, they're cleaning the rooms, and they get minimum wage. And then you've got the janitors, and they're almost all women. Like, I don't even know if I've ever seen a housekeeper in a hotel who's not female. And then you've got the janitors who are working in the hotel, and they're emptying the garbage, and they're cleaning the floors out in the regular space, and they make $18 an hour. And they're almost all male. The skill, essentially the same for those two jobs. Effort, how hard is it? I think stripping sheets and cleaning the bathrooms and picking up the taxes, just as hard as cleaning, the grounds and everything else. Responsibility, right? In the room, you've got access to people's valuables, and probably guests care more about what's going on in their room than the lobby anyway. Similar working conditions. I think any hotel that is paying their janitors different than their housekeepers, this is where the lawsuits are going to come from. Okay? Another example, your city. What do your social workers do? They got to go into homes with volatile situations, mental health, drug issues, and try to get kids out safely, right, for public health and safety of our community. Social workers are almost all women, and they make like 33 grand a year. What do police officers do? They go out in the community. They enter into volatile situations to try to diffuse it to keep our community safe. What do cops make? They make like 75 grand a year. And I'm all mostly male. So these are just some examples. If I was a plaintiff's attorney, I would have a field day with this new law. So my guess is it's out there and it's brewing, and it's going to be really interesting to see where it comes out. But if you don't want to be one of the test employers, you might want to look at, do we have classifications where there's lots of women, What are they making? Classifications of men as a group. What are they making? And can we justify the difference based on those? So it's going to be very interesting. You are allowed to pay people difference, right? Length of service, right? Like I pay people who've been at my firm 5 years more than one. Loyalty counts for me. Plus, you know my clients, you know the system. You're just more valuable to me the longer you've been there. Education, training, and experience, of course, right? If some people need a college degree and others don't, you can pay for people who have more training. They're journey level workers versus apprentice, obviously. Regional differences, right? I'm not going to pay the people in Kirkland the same as I'm paying people in Yakima, right? Cost of living, right? So if you say, gosh, we've got men and women in both, but we happen to have 20 men and 5 women in Seattle, and this is what they make, and we've got 20 women and 5 men in Yakima, you can explain it by cost of living differences or any other bona fide job-related factor. But the employer's got to prove for these factors based in good faith, consistent with business necessity, it's not based on gender, and you got to account for the entire differential. So I don't want to be the employer who's the defendant on these cases as they come out. So how are they going to, the legislature's like, well, how are we going to get people to flesh out if people aren't getting paid fairly? Because a lot of employers are like, you're not allowed, you signed this agreement, you're not going to talk about how much you make, and you're not going to ask other people, well, guess what? You cannot require employees to sign non-disclosure agreements saying they won't talk about how much money they're making. And they can't be retaliated against for saying, hey, this is how much I make. Someone else, you tell me how much you make. What's your name? Mouthful of food. Stacy. Stacy is making $40,000 a year. Do you know she's making $40,000 a year? How much are you making? 30? Well, how much are you making? 70? Oh! Right? People are allowed to ask you to justify, so you can't retaliate against me if I come and say, hey, how come he's making 70, she's making 30, and she's making 40? What's up with that? Let's hear an explanation for these differences. I think this is going to create so much bad blood and bad drama in the workplace, but this is the law. And you can't retaliate against me if I am encouraging people, hey, everybody, I'm starting a Facebook page, or I've got this Google Doc. Everyone, just put a nickname and how long you've worked and how much you're making. And if you're a male or a female, let's see what's going on here.
Karen, I have a question about this topic really quickly. So what if you have employees who have specific higher security access to wage information, and they're taking advantage of that access to snoop, as it were, about what other people are getting paid? Is that protected activity?
I think it would depend on their role. That's a good nuanced question. Mm-hmm. I would want to know more about the facts of that, but that's going to be one. Boy, that is a good one. It seems to dance right over the line of the law. Yeah. I don't have a great answer on that one. I would want to be really strategic about how we talk to that person, or when you're in HR.
Yep.
Yeah. So they can go back 4 years from the last violation. So if we find out 2 years ago you were treating people fairly, we're going to go back 4 years before that, find all the women who weren't paid as much as they should have with the men, and you're going to owe them all back wages. I'm the plaintiff's attorney, back wages, triple damages, and attorney's fees. Cha-ching. Although you've got a 3-year statute of limitation, but you've got 3 years from when it happened, but then they will go back. They can be digging back 5-6 years because of that timing.
Can it go both ways, that if the women are in your organization highly compensated?
Yeah, it's both ways.
So it could
That's not typically the pattern in our society.
But if there's...
let me know the name of that employer, because I might want to go get a job there. Okay. The enforcement agency is Labor and Industries, although this is the important part. They do have a private right of action. And if there has been a problem, this is where the money's going to be, attorney's fees, triple damages. They may piggyback together as they do on some of the other discrimination cases. Yeah, and so these are some of the that's the basic law as it stands. I haven't seen anything exciting come out of it yet. I'll probably do a public disclosure request to the Department of Labor and Industries before the end of the year to ask which complaints have come in, what was it about, and what have been the department's finding. I want to put my finger on the pulse of how they're looking at it, where they're drawing the line. I do that for a lot of my work. I do public disclosure requests to find out what's really going on down in the weeds. So this is the Equal Pay and Opportunities Act, some new updates. Now, when you're hiring people, you can't ask them, what did you make at your last job or your last jobs? And for applicants and existing employees, I think it's if you have more than 15 employees. This new thing is only if you have 15 or more employees. Because like in my office, I've got, you know, a non-equity partner and 2 other attorneys. And if they're like, give me the range of attorney salaries, they're pretty much going to know what other people make because it's such a small office. But you've got to tell people the wage scale or salary range to applicants, right? Our superintendents make between $90,000 and $140,000. You've got to give the low end, the high end of what you pay your superintendents, or whatever. Or if someone wants to transfer, right? I worked as an estimator, but I want to be a superintendent now, and they say I want to know the salary range for superintendent. You're going to have to give up the wage scale or salary range.
If they ask for it, we have to give it to them, or just if they're
If
like,
they ask for it.
Okay.
And again,
Do they have to be transferring jobs, or any employee at any time can say, I
no,
want
it's only if you're moving into that new position you can ask about it. So yeah, employers with 15 or more employees have to comply. I don't think from your job applications or in your interviews you can ask, what did you make? I want to know. First of all, I don't want to be the jerk employer who offers them less than they were making before. Like but so I ask and think, what are your salary expectations? Because if they say I want to be making between 60 and 70 and I really love them, I might offer them, 70 and a signing bonus because I want them to know how much I want them. So that doesn't directly conflict with this law, because maybe they were making 20 at their last job and they've done research and they think that's what they're worth. That's great. But I don't want to be just shooting in the dark as an employer, not because I'm trying to undercut people, but more I just don't want to embarrass myself. So train people in hiring not to ask about it. And then when you do get a request for the salary information, you need to timely provide it. I'd also think this again, though, creates a bunch of drama, because if you have to disclose, our superintendents make between 90 and 140. What's the first thing that's going to happen when that gets out?
Why am I making 140?
Who's making 140? Jim, are you kidding me? Jim he's friends with the owner. He's not even that good. Or I'm the one, the range is 90 to 140 and I'm the person who makes 90. Why am I making 90? Right? It just, they think it's going to create a lot of drama. But I guess the legislature, they said, well, that's fine, but we want things to be more fair. And this is mostly along gender lines, that women are paid less than men when they shouldn't be. That's where the legislature's trying to get to. And there is something where women often have more teaching, social working, other types of jobs, and then they want to leap into management, and they've developed the skills. Like, I love getting homemakers back from the workforce, time management, budgeting, multitasking, prioritizing, right? If you've just gotten done raising 3 kids and now they're in middle school, if you're one of those super moms, like she's got a lot of transferable skills And the fact that she's made nothing or just maybe had a part-time job doing something else shouldn't impact her value. And I think that's where they're trying to get.
Would this apply to asking data about other offers or just to their actual salary?
I think it's their actual salary. If you're competing for them and you want to say, well, do you have any other offers on the table from other companies and what have they offered you? I think that's safe because that's not something you've earned yet. Now you're just trying to compete for that person based with what else was put on the table. Anyway, so interesting. All right, so that's the equal pay. I'm not a fan of that law, but I'm not here to tell you what I'm a fan of or not. I'm here to tell you. So don't shoot the messenger, by the way. Okay, I didn't pass all these laws. I'm just letting you know what's out there. There's new restrictions on non-competes, and they are substantial limitations compared to before. And yet, again, it kicks in January 1st, 2020, and it is retroactive. So if you have existing non-competes, you need to look at them, see if they comply. My guess is they won't. And then you need to re-offer or re-put non-competes that are consistent with the law in front of people and offer them some consideration. Like, before we give you your year-end bonus, or, you know, if you want your year-end bonus or the raise or whatever, we're going to need to do new non-competes. There's a new law, because if you ask them to do that without consideration, which is basically money or something extra fancy for them, they can get thrown out. It doesn't have to be a lot. But if you use non-competes, it's time to get this on your radar in the next couple months. So they're limiting. One is, if you can't have a non-compete if someone makes under 100K, 100,000 a year. There, of course, bad facts make bad law. There's like pizza joints that are like, our secret fast food proprietary processes and information is so secret that you can't go work at any other fast food establishment within a 25-mile radius for 2 years after you quit work. So now they got the person trapped making $13 an hour, who could maybe go to the fast food down the road and make $15 an hour, but he's got a non-compete because of that proprietary information, and then that's wage suppression. That's a lot where this comes from. So bad facts make bad law. And I don't agree with fast food. It's like, it's not that proprietary. Your special spices are not that special. And hi, can I take your order? Like, that's pretty straightforward. And if you're using a contractor, they have to be making at least $250,000 a year before you can have non-compete language on them. You can't do it more than 18 months. Many non-competes were 5 years, 7 years, very long period of time. You're limited to 18 months. And if you lay off the employee, you got to pay them their base salary if you want that non-compete to stick. Stacy, right? So Stacy works for me, and she is my chief estimator, and we have our special secret estimating program that we underbid everybody but still make a profit. And I don't want my competitors knowing about that. And I pay her $100,000 a year plus bonus. But work's slowing down, and I'm going to have to lay off Stacy. I can protect that proprietary information for 18 months, but I'm still going to have to pay Stacy her $100,000 a year. I don't have to pay her the bonus, but I still got to pay her base salary if I want that non-compete to stick for that 18 months. Or I've laid you off, Stacy. You can go job hunting, but then I'm not protected by the non-compete, and she can be taking that proprietary information she's got locked up in her head with her. So.
And that's true even if you offered some other form of consideration for the initial signing of the non-compete.
Yeah. I mean, but think about it. How horrible for Stacy, right? Now, I've laid her off. She was willing to keep working for me and keep her secrets. Now she's unemployed and she can just go work at Starbucks, right? So there really is a fairness issue there that I get. I mean, at least that has a rational basis to it. If it's that important that that stuff keeps secret, I need to keep her employed. Or if I lay her off, it better be worth $100,000 to me. I guess the message there is have really low base salary and a lot of bonus, right? If I knew this was coming, I'd be like, hey, I'm paying you $40,000 a year plus $25,000 bonus every quarter that you perform adequately. And then if the non-compete doesn't stick, I would have the argument that your base salary is 40. Whether that would pass the sniff test with the courts, I don't know, but these are the things you're gonna have to think about. You have to disclose in writing, this is our non-compete, prior to them accepting an offer, right? Because it's Adriana. She's working at CITC, and I offer her a great job. Come work at my law firm. I'm going to pay you $50,000 a year as a beginning paralegal. You give notice at your other job. You show up for me the first day, and I'm like, before you get paid, here's the non-compete. You need to sign it. And it's like, you're never going to be able to, you know, she's going to be like, what? No, I don't want this job if that's what's going on. So they want people, before they accept your offer, here's your package, your pay, your bonus, your vacation, and the non-compete needs to be up front. So they're having a good hard look at it before they say, yes, I'm going to come work for your company. That one actually seems fair, right? I don't like the gotcha laws, right? Like that again is not transparent. It's not respectful. So these are the new, so if you have existing non-competes and you want them to stick, you better look at them between now and January 1st. So employees can sue if you violate this law, and the Attorney General's office can sue for any employer who tries to enforce a non-compete that is not compliant with this statute. They can get their actual damages or a $50,000 penalty, whatever's more. Maybe the fast food worker, you know, really was only out $2,000, and then he found a job in landscaping, but he said, I would have made $2,000 had I been working at Jack in the Box, but, you know, Joe's Pizza said I couldn't. So they're going to give him at least $5,000, make it worth their while. This is where the rubber meets the road. Reasonable attorney's fees. These plaintiff's attorneys are just, I mean, I just can't be a plaintiff's attorney because I really like sleeping at night and having but this is just easy money, right? If they can get into one of these, because maybe I'm only getting Stacy $15,000, but boy, I'm worth $500 an hour, and it took me 50 hours, so you owe me $25,000, a large amount of money for me getting that recovery for her. Also, you can't prohibit employees who earn less than twice the minimum wage from working a second job. Like I tell my attorneys, you can't work a second job. Your salary exempt. So I own, you know, kind of the firm owes you. Some weeks you work 25 hours, things are slow. Some weeks you're going to work 70 hours, right? If a fatality or incident happened, we're boots on the ground now. Get your PPE and get there for the employer and help them out. So I'm allowed to say you're not allowed to work a second job. But I can't tell someone, a file clerk who I'm paying $17 an hour to, I can't say you can only work here, you know, these 25 hours a week, you're not allowed to work anywhere else. So that's how that works. So the takeaway, review your non-competes. You're going to want to re-offer to existing employees, revise for new hires, enter into new agreements, and then check each year, right? If someone was making $100,000 a year, but then they weren't getting their bonus or it falls below it, then maybe then it won't stick, the second job business. So these are just things to keep in mind. Okay, any questions before we get to that exciting topic? Any questions about non-competes? All right, it's not getting any more friendly for employers, again. Protections for pumping breast milk at work, the need for accommodation, the appropriate room, the appropriate breaks. I'm trying to remember, does the employer have to provide refrigeration, or is that on the employee?
I think it is on the employer.
Yeah.
I think you have to have refrigeration on-prem.
Yeah.
On premises.
Yeah. Anyhow, it now is 2 years that's protected. There you go. I'll keep any comments to myself. Okay.
One more year to go.
There you go. Fair Chance Act. Okay, this is the ban the box legislation, is what it's often called. This is about asking about felony history. This kicked in last year. We're going to talk about who's covered, what prohibited conduct is, who enforces it, and so on. So this applies to every applicant for every job, unless they're going to have unsupervised access to minor children or vulnerable adults, working in a nursing home, working in schools, daycares, things of that nature. Certain financial institutions, banks, are allowed to screen. Law enforcement, of course. Securities and Exchange Act, like, dealing with big amounts of important money. And non-employee volunteers. Like, I'm in Scouts, so they're checking my criminal history frequently. And that's not a bad, I'm fine with that.
Uh-huh.
But for the rest of us out there in the business world, you, like everyone in this room, I would imagine, this applies to your businesses. So you cannot consider criminal history until you've first determined if applicants are qualified for the job. So you're saying we want a journey level electrician with 8 years experience, working in large institutions, educational, university or whatever it would be. So you get your applications and you're allowed to sort. Oh, only has 2 years. They let their journey license lapse. They're not, licensed. And now you've got your 2 piles and you're allowed to do that. Now you've figured out who is not qualified and who is qualified. Then at that, and you can't advertise the position ahead of time. Don't apply if you've got a criminal record, or on the application, check about it. They want you having a clean eye and kind of a fresh face on people on that, at least that initial screen of who is qualified for the job. And you can't say if you fail to disclose it, we weed you out. They're not going to let you dance around this. And you can't go on the internet and do Google searches to find out if they have a criminal history. You've got to say you had fresh eyes on your applicant without regard to their criminal history. So this otherwise qualification can technically happen before the interview stage. I think they want employers, like, look, if these are your 8 candidates, they look pretty good, but you haven't considered criminal history, they would like you to give everyone an interview. You just might be impressed with somebody despite, 6 years ago, I was going through a divorce and I wrote a bad check, or I don't know what the story is. But the public policy is, if we keep punishing people who've been in prison, and we want them to be productive members of society and earn a living so they don't do illegal things and go back to prison, we got to give them a chance to at least sell themselves. And I'm a pretty strong believer that that's good public policy. So that's where it's from. But once you've said who's qualified and not, then you can start asking about it. So you could even ask before the interview stage. I think what they'd want is you're allowed to bring people in who has the right soft skills, hard skills, and then we're going to do a criminal background check. Then you can talk about it, and then that person can say, yes, I've had it, but I still think I'd be a great employee for you for XYZ reason. So that's the public policy behind it. Now, remember the other ones? I was like, private right of action, attorney's fees, expensive. This one, the teeth for not getting it right are not very tough. Enforcement is through the Attorney General's office. They'll send an investigator out, respond to complaints. The first step is they tell you don't do that. They get a letter that says, hey, you're not allowed to ask about criminal history until you get to XYZ point. Step 2, $750 fine if you do it again. Step 3, up to $1,000 for additional. They might say per applicant and try to really make a point with you. The big story here is mostly you're not allowed to ask for it, and they want employers to give these people a chance. But the teeth, if you don't get it right, are not terrible. So, any questions about the ban the box legislation? I know ABC, I don't know if CITC is as well, but there's a big push to get people into construction who are coming out of prison and do have felony history because there is a labor shortage in construction, and there's a couple nonprofits that are working really hard on that actually. So it'll be interesting to see how that goes. And that might be an organization that makes complaints because they're getting people trained, they're trying to get them the hard skills and the soft skills. Then they get out there and they're not even getting a call or interview when they appear to have all the training that they need. Okay, so a few years back there was expanded, first of all, anyone questions about the ban the box legislation? The tricky nuance is I am Jim's electrical company, and we work in downtown office buildings, we do some residential, but occasionally we're doing electrical work at elementary schools, right? We help do the electrical, right? Are they exposed to kids? Not really unsupervised, but that's the weird one there. I think that they're saying this is more a counselor, you're in scouts, you're hands-on, one-on-one with kids is what they're looking for. But even so, I don't think you could just say, we will not hire you, because you might get dispatched to a job like this at some point. My guess is you go through the process, you're otherwise qualified, then you run the criminal background check, and hey, if we get that job and it's close, maybe you don't get dispatched to that job if there's going to be kids in the school. Talk to me or somebody about those nuanced lines. But unless all you do is, we do electrical for daycares or for nursing homes where there's vulnerable adults or kids, then that's a finer line of how you deal with that. All right, domestic violence victims, there was expanded law 3-4 some odd years ago. That has been, they're entitled to reasonable leave, right? They can take a leave of absence for kind of an indeterminate amount of time, which was very difficult for employers because they never know, are we talking 2 weeks, 2 months, 2 years? Because it wasn't defined how long they got off work. But this is some expanded protections. So yeah, they're entitled to reasonable leave, but now you can't refuse to hire somebody because of domestic violence issues or take an adverse employment action. I don't want to give her a promotion. You're not going to get the raise. You were out a lot due to all that drama. And you must grant reasonable safety accommodations. So what do those look like? Maybe transfer or reassignment to a different location, modified job schedule. Maybe that's not the person who's the last person to lock up and leaves the building by themselves. Maybe change their work telephone, email. I have a woman in my office, she's not on our website because she had a stalker situation before I hired her, and she doesn't want it known where she works or have her picture out there. More locks. Well, we have a policy if there's 2, because my office is mostly women, we have some men, but if there's 2 or less people left in the office, the front door gets locked, and then people will have to call or ring in if they want to come in. Other safety procedures, adjusting job structure, the facility. So if someone's in that situation, you're required, it's almost like, reasonable accommodation that you make for disability. Just kind of keep that same mindset. If someone is in a domestic violence situation or has a stalker or those kind of situations, you're going to want to make accommodations so they can safely do their job that will look somewhat like this. And for me, these are smart to have anyway, because, and for all of you, you could have a disgruntled worker, right? Like, what kind of safety precautions do you have from when you let somebody go? And for me, I deal with workers' comp. There's workers' comp claimants who are really mad we're trying to deny them benefits, or a plaintiff in a lawsuit that they should have paid my overtime. And, it's not unheard of that there might be angry people who want to come to our office. And then there's mental health issues and addiction issues that people are often not in their right mind. So these are good safety precautions to be thinking about in your place of business. Anyway, it makes me sad because I just felt like when I started this job 30 years ago, around Seattle and in Washington. You open the door and you can walk right in and, hey, Joe, the CEO, how you doing? And but it's just times have changed. So thinking about safety in your workplace, it's required if there's domestic violence victims, but it's probably not a bad idea for workplace safety anyhow. And liability, right? You don't want someone who comes in and they're severely maimed and they make a claim against your workplace that you were negligent in not having basic safety procedures for employees. Non-disclosure agreements. This is out of the Me Too movement, right? We don't want to be doing hush hush. Don't talk about it. You know, Jim, the CEO, is, you know, harasser and molester, but every time, like, you're not allowed to talk about it, and you can't do this, and we pay you off, and you go away, and then it keeps perpetuating itself. So these laws are about, no, we're not going to allow that anymore. This is what it looks like. So you can't retaliate against someone who discloses or discusses sexual harassment or sexual assault in the workplace. This includes work events, you know, the Christmas party. I do a lot of training. It's still a work, even if you go to a conference in Vegas, that whole trip is still work related and your behavior counts, which is why I don't suggest doing work trips to Vegas. It's very easy to slip into, right? Like my suitcase and the shoes I pack on girlfriend trip to Vegas is very different than a work trip to Vegas, but those lines can get blurred really easily. So you can't require employees to sign non-disclosure agreements that prohibit discussions of sexual harassment or assault. So we're just, these hush agreements, like if this happens, you just can't proactively say, come work for me. But if you get harassed by the senior partner, you're not allowed to talk about it. You have to not say anything. That's not allowed. So you can't have it as a condition of employment. And again, they want this out in the open. If you're a good employer, this stuff isn't happening in the first place, so don't worry about it. If you're an employer who's nervous about these new policies, you probably have some HR issues to deal with. And the problem is when these people own the company, right? I've got clients where the HR person's like Karen, our owner, still, you know, slaps women on the butt as they walk out the door and, hey, honey, and right, and because that's how his grandpa was, and that's how he was when he started work in 1957. It's just, you know, times have changed. So, you know, we talk about risk to the owner, right? Times have changed. This can be very expensive for you. Now, this doesn't apply to HR staff, right? Like, actually, if you are doing an investigation or you find information that there's a certain point where confidentiality needs to stay in a group that's dealing with them, because they're expected to make confidentiality as part of their job. Now you can still settle out. Okay, so Stacy, something happened. I am so terribly sorry. You know, we have chastised that person and they've got a written write-up and we feel terrible and we really appreciate if you didn't sue. And so we're going to pay you $20,000, but we'd like, you know, this is a confidential settlement agreement. We won't say anything. You won't say anything. That in general is allowed, but in limited circumstances, you're allowed to bring it up later without losing your money or me retaliating against you. And that's going to be if there's a lawsuit, right? The next person down the line, they are suing because they were sexually harassed or assaulted, and she's suing and she wants to call you as a witness in court, right? We're going to take your deposition. You tell us what happened to you, because she's saying there's a pattern there. You're going to be allowed to produce evidence without losing your agreement money, and I can't discriminate against you or retaliate against you. And I understand the public policy behind this one. I'm pretty behind this one. Yeah, so they're allowed to testify. So if you got a problem employee, you're not just going to be able to hush it up with money and assume that it's not going to be a problem in the future. I love these. You are no longer able to take a tax deduction related to sexual harassment or abuse. So I can't write off as a business expense the $20,000 that I paid you, right? Or my attorney, let's say I hired another attorney to handle it because I thought there'd be a conflict of interest. I can't write off the $20,000 I had to pay that other attorney to investigate and help me draft the payoff agreement to you. That's not going to count as a business expense. So, yeah, the Me Too movement, these laws have changed. All right. Any questions about the harassment, discrimination, settlement agreements, payoffs, any of that? If you have one of these problem employees in your organization, you really want to think about the risk to the organization of keeping them on, no matter how much money they bring in, right? Sometimes they're superstar players, right? They're the ones that land the jobs. They've got the dynamic personality. They've been around forever. I'm a part owner in the business. And so people have been willing to say, well, yeah, he is a little touchy-grabby, but, you know, Jim really lands those deals. It's worth it to keep him. These type of laws are making it so the math adds up. No matter how dynamic and great job performance-wise, it's too big of a risk to keep Jim. If anyone's here named Jim, I'm sorry. I'm so sorry. That's like Joe Smith. All right, Jim, I'm not talking about you.
Yeah.
Yeah, we'll have a little one-on-one coaching after. Arbitration and employment agreements. You can't make people waive their right to file a claim with the Human Rights Commission or the EEOC. You know, those rights are there. Even under a collective bargaining, you can't tell a union person, hey, you have to go through the union grievance process. You can't first go to the Human Rights Commission or the EEOC. So because they don't want this all hush-hush. So again, this is why proactive training doesn't need to be me, but I do harassment and discrimination in the workplace. I'm doing one-on-one coaching. Unions are paying me to do it because the union people are losing their jobs and getting fired because they're really great at welding, but they just haven't kept pace with the kind of behavior you need in the workplace and the kind of filters you need to bring to work that their dad didn't and their grandpa didn't. So if you are not training people that times have changed, and honestly, construction is a little slower to the change than some others, but clear down to the foreman, if not employee level, up to superintendents, getting people on board that just because you're on time, under budget, and you didn't have any injuries or safety issues, you know, great, but you also are responsible that we don't get a harassment, you know, discrimination based on LGBT, someone was making remarks about someone's religion. Those can blow up and be more expensive than any cost savings that you and profit you made on that work site. So think of proactive training because the workplace has changed and the bar that it used to be for a harassment claim used to be up here. Oh, it had to be severe or really pervasive. The bar's dropped. The tolerance for what people should have to put up with to do their job is now down here. All right. So you can't tell people they can't pursue their rights. You can't, yeah, that's. And then also, I can email this presentation out in a PDF. My business cards are over there. And so if you just send me an email, Karen, I'd like a copy of the presentation. I'm happy to send it to you if that's helpful. Overtime. Okay, so wage and hour. How am I doing on time? I've got to 1:30.
Yeah,
Okay.
no, 1:30. Yeah, you're doing great.
All right. Thanks. I appreciate the process. Praising. I'm learning as a boss to praise more, right? Because I'm such a perfectionist that I'm always like, this could be better, this could be better. I'm learning to remember to tell people what they're doing well. So I appreciate the feedback, David. I wasn't sure if you were talking about my presentation or time, but I'm going to take it as both.
Yeah, it's really good. All of it.
Excellent. Okay. Wage and hour. If I ran a business like any of you in construction, I'd be shaking in my boots about wage and hour claims. I think most of you at AGC, but not all, use a union workforce. That's actually to your advantage because it is much more structured and clear, but you also need to think about your non-union employees in the office and management people. Who is exempt, who is non-exempt, just because you call them hourly or hourly does not mean you're categorizing them right. When do people start getting paid on the clock? The whole lunch Do they get paid during lunch? What if in the office they're still answering their phone and checking texts while they're eating? Is that an unpaid lunch? Is that a paid lunch? 2, paid rest breaks. Are those out? How you're dealing with those. These are all huge areas of vulnerability for employers, and the lawsuits are coming, and they're coming with class actions. It's not just 1 or 2 employees complaining. The plaintiff's attorneys, if they can get a little bit of their claws in on 1 or 2 or 3 people, then they say, we want class action. If it's bad for them, it's bad for everybody. Let us stand up for the worker, and they're just getting tons of money. And wage and hour is not covered by EPLI insurance. Employment practices liability insurance that you may have for your company does not pay on wage and hour. At best, you can get some of your attorney defense fees covered under an EPLI policy, but you're going to pay out of pocket. So this is what's coming with labor and industries. They're proposing an increase to the amount of money that people need to make before you can call them salary exempt. Yeah, they want it to be 2.5 times the minimum wage is the point at which you can say someone's salary. So it's a big jump. I think the problem is they were paying people $26,000 a year and called them a manager at the Gap, and they're working 60 hours a week for that $26,000 a year. And the basic feeling is if you're really management and that in charge, you should be making at least $44,000 a year. You're really not that skilled of a manager and in charge person. Like it didn't pass the sniff test. And I kind of think they're right on it. The problem is in Eastern Washington, you know, $32,000 a year is pretty good money in, you know, Umatilla or some of the smaller, more rural areas. So this is going to be a much larger jump for them. But you can pay people $15 an hour plus overtime. So if you had someone who was working a 60-hour week, make their base salary for the 40 much lower, do the math with the worker, and you usually work 60 hours a week. So with this extra 20 hours at time and a half, you're still going to be making the same money. So I think there is a way to work around it, but you're going to need to work around it. Well, these are proposed, but they're going to go through. It's the Department of Labor and Industries backed by the legislature, backed by the Senate, backed by the governor. And these are some of the rollouts of the minimums. So, and the bigger your company is, the more you got to pay people to be saying that they're truly exempt. So I think there's still time to weigh in at the department. They did have open meetings, but I'm not even sure it's worth wasting your time complaining about it. I think it's a done deal. So these are some of the laws that have changed, a few court cases, new things that have come down from the legislature. I think City of Seattle just had something roll out within the last week, but I can't remember what it is. But if you are in the City of Seattle, you need to spend the time to look at their leave laws because they are different sometimes than what there is statewide. And of course, they are more onerous and more protective of workers. So please look at your handbooks. Please look at your contracts. Payroll. I never push the whole payroll review as much as I have in the last year and a half because that's where I'm seeing the expensive lawsuits come from. It's your payroll practices. What are you calling people? How are you paying them? How are you tracking the dollars? Who are you saying is exempt? Who are you saying is non-exempt? I'm seeing more lawsuits there than I am harassment and discrimination. Yeah. So your wage and hour payroll practices, the plaintiff's attorneys are hungrily swimming in those waters. So please make sure you are taking time to get those up to date. And now time for questions, concerns. I can't give you client advice, even if some of you have been clients. I wouldn't talk direct client advice in front of other people. And if you're not my client, I can't give you client advice. But we can talk in generalities or hypotheticals or trends that I'm seeing perhaps. Yes.
What have they got sorted out in regards to the Family Wage Leave Act? You know, if they've kind of come up with some more definitive aspects for that implementation at the first of the year?
I haven't seen anything new other than what's on the books, but,
It's still a wild guess.
yes, as far as I know, but I probably will, as we're getting, August or October is gone. We only got 2 months left. I'll probably be circling back to see if there's any more specific guidelines or guidance on that. And then there's the whole senior care payroll program that also got rolled out. So yeah, between sick leave and paid family leave and the paid elder care laws, there's a lot going on. To make sure you're doing the right deductions out of payroll, first of all, and then once they actually, benefits can flow, who, what, where, when, and how they get those benefits. Yeah, that's.
Should we be expecting some final rulings as it relates to mandated employer postings though?
I don't know.
Yeah.
I've been refreshing the site every once in a while, and it just
Still.
still says,
Stay tuned.
yeah. For the,
I've seen this movie before.
What was the question about what?
I think one of the most critical things for us outside of payroll contributions, employer and employee, are going to be the mandatory employer postings. Since it's a state-run insurance program, from an HR benefits admin perspective, I'm not concerned. Other than making sure that our policies align, right? So whatever we choose to have for paid leave or unpaid leave internally, how that coordinates with the state insurance-run paid leave program. Other than that, I'm not worried about it.
Yeah. There was a domestic violence poster on the ESD site last month. That was new.
Correct.
Is it a required posting?
Yes.
You know, I will talk with Sonia about, there's always the AGC newsletter that comes out, which I actually read, that would be a great place to either provide links to or attach PDFs of any new posting requirements on some of these new jobs. Since that gets blasted out across everyone with AGC, it seems like a really good forum to get those out there.
And we purchase our all-in-one posters from AGC. So if it's a mandatory posting, hopefully the next version of it will have that.
It can't get any bigger.
I know. The type is going to get smaller and smaller and smaller.
I'm just making a note so I don't forget. I didn't know about AGC having one that covers, is the AGC of Washington? Has it?
I think it's a product of AGC National, but
It
it's
is, but
distributed.
We customize as best we can, yeah, through our.
It does
safety
have
team.
Washington, yeah.
Yeah. But.
So make sure safety team is looking employment law as well, because we don't want to just be wage and hour, safety, workers' comp, when there's all these other
Right.
employment laws.
Right.
So you don't want contractors relying on you for proper posting when it only covers 3 silos when we need to be covering 5.
Exactly.
And maybe AGC wants to have 2, one that's more employment law based and one that is kind of L&I, wage and hour, minimum wage, safety, workers' comp, because those are going to be different. All right. Any other questions, concerns, or yes?
Back on the salary history questions. We have some hiring managers who get emails from outside recruiters, and sometimes those emails include salary information, whether it's expectations or history, I don't know. But how much should I push back?
Well, I think you're not allowed to ask for it.
Okay.
If it's pushed out through a third party that is kind of improperly asking for it and provided to you, that sounds to me like a dangerous gray zone.
Yeah.
It's almost like Googling on the internet for felony history. I didn't ask the worker about it, but I certainly found out about it. That seems like if I was playing it safe, and I'm not the attorney who always says, here's the safest route. I have an attorney in my office who's like, this is because I'm a business owner. It's like, well, sometimes I want to manage my risk right here.
Yeah.
That I might be asking the recruiter to talk about salary expectation or expected salary, assuming that recruiter is factoring in how much more they want to make from before. I'd be a little nervous about that one, actually.
Probably makes
Also,
sense.
recruiters always want you to pay more because they get a percent of the money. Like, I don't trust recruiters at all because they have a profit incentive that's contrary to my best interest. My best interest is pay someone $50. By the way, one trick for that is you pay them 50 with a huge bonus because you only have to pay the recruiter a certain percentage of their base salary. But yeah, I think there's a conflict of interest, what's in recruiter's best interest and yours, and then this law. So it's something to think about and decide where you want to manage your risk in there.
Wouldn't it make a big difference if that recruiter is somebody that you're contracted with versus somebody that's just saying, hey, here's a candidate you might want? 'Cause
Yeah,
we get
if-
those all the time that they're trying to push somebody and they might say, you know, this is what they're looking for, this is what they've made in the past. That's just voluntary information, right? You're not soliciting, but if you have a contracted recruiter that you're actively searching.
Right. What's your name?
Adam.
Adam, that's a very good point. If you have said to a recruiter, this is what we're looking for, go find me candidates, I think you need to make it clear. We just want to know salary expectations. Whereas if someone unsolicited contacts you and say, hey, do you have a need for a superintendent? We've got Joe. He was making 40 at this company. He wants to come in the 45 to 50 range to make a move worth his while. You didn't ask for it. It was kind of pushed to you. But yeah, if you have asked the recruiter to go do it, if they're your agent, so to speak, then you can't, I would then tell them to not give that information. At least not in writing. Yeah. Any other questions, concerns, issues about, so anyone in HR, you should have a lot of job security because what you need to do is only getting worse. The risk to employers. I do safety and I do comp. I know best practices on comp, but people are getting better about safety in general. Washington's one of the safest states in the country. But this employment law is a real area of risk vulnerability. And I think a lot of people old school in construction just don't think about it. So your job in HR is to elevate that to ownership. You can strip out your profit margins really fast with some of these issues.
There are some areas like New York has passed some legislation about not drug testing for marijuana before an offer is made.
Washington is still holding strong, shockingly.
Yeah.
It's holding strong that you can test out for marijuana. There's no job protection under medical marijuana or recreational marijuana. And we have Supreme Court cases that say so. How long that lasts, I just say make hay while the sun shines if that's how you want to go. I actually have some big general contractors who are saying, Karen, we don't want to screen out for it because, we're losing 30% of our applicants under age 30. There's a labor shortage.
Only 30%?
I think the problem is for alcohol, there is an immediate way to test for impairment, right? So, yeah, you had too much like last Friday night, but by the time you get to work Monday, we can do a blood test and you're 0.001% blood alcohol. That's fine. The problem is if we test for THC, you were in Jamaica 2 weeks ago, but you're fine right now, or you got high before work, you're still impaired and it's in your blood, and there's just not the ability to tell how impaired someone is if we find it in their system. The person who invents a way to test for level of impairment, so kind of the 0.08 or whatever we use for driving or at work, then I think it's going to open the door, because really we just don't want people to be impaired. I don't think people are really judgy, like, oh, you do that. But it's more, there's a danger of impairment, and we just don't have a way to know. And most everything in construction is safety sensitive. Anyone who drives a car, it's safety sensitive for their job. And so that's where it's holding right now. But I think there are a lot of employers who would ask about the wiggle room. But in Washington, most of my big contractors, because of federal contracts, it is illegal still federally. And I don't think anyone wants to be the first one to stick their neck out. First of all, you're going to get all the weed smokers coming and working for your company, right? Like all of a sudden GOI is allowing weed smokers. Woo! I'm glad GOI. Then now you're just not going to have, now you have 70% of your workforce who smokes weed. So I don't know.
Now there's a lot more Cheetos in the snack room.
Yeah, I know.
Or a lot less.
So that's where it's at. If you're a multi-state employer, the laws on medical marijuana, protections in workers' comp, let alone accommodation, it's all over the map. It's a real patchwork right now. But in Washington, you're safe to test and exclude for it. Please let your workers know very clearly. Don't just say, we test for all illegal substances. You want to make sure we test and it is disallowed for these drugs and also marijuana. While it's legal in Washington, it's illegal federally, that is still a disqualifying substance. Again, for employees, people don't like surprises. They don't want to feel disrespected. Be really transparent up front. I think the bigger safety sensitive issue I'm seeing in construction is people have a prescription for and are taking opioids on the job. Because I don't really care if it's heroin or OxyContin or fentanyl, right? Whether you have a prescription or not, those are impairing medications. And right now, I kind of feel like there's a don't ask, don't, oh, you got a prescription, go ahead and operate the crane and work the backhoe. And, I think there's a safety issue that if you're taking certain opioids and working, can you safely do that job? Can you do the essential elements of that job safely? And I think there's a real question. And I haven't seen an employer really go at that. They're kind of like, well, their doctor said they could. And I would like to see the construction industry, and I do feel bad for the workers. Man, I hurt my hip. But if I don't work this job, I'm good for $16 an hour in the plumbing department at Home Depot. This union job is what pays my mortgage, and I want to keep doing it. But I can't function with this pain without this oxy whatever, or I'm addicted, or whatever it is. It's very sympathetic on the worker side. That being said, if they get hurt, if there's a fatality, all that risk goes on the employer, and you pay for it. So just something to think about. I don't have the right answer on that, but for me, that's a big safety concern. Because I do a lot of training on opioids and addiction and whatnot in the workplace. And to me, construction companies have not addressed the safety issue when there's a prescription involved. And if someone company has, please come talk to me privately because I'd love to hear about how you're handling it. Any other questions?
So a couple quick points. Karen mentioned the slides, and that'll go out to the list that I have. So if for some reason you showed up, you didn't RSVP, that's fine. Love to have you, but just make sure if you're hoping to get those slides, check this list or the one sitting over there by the lunch deal and write your email in there if for some reason you're not on here. Second thing, make sure to get that parking pass for those that came in late. You're going to want that sticker to throw on your card. And third thing, best way to do trash, just toss it back in the box and you can leave the box on the table and we'll take care of it afterwards. So, Karen, thank you so much.
Thank you so much for having me.
Okay. So, we have recommendations for HR consultants. Because I just thought that some employer could hire on like a weekly type thing without having a full HR department.
Yes, HR